Welcome to the March 2025 New Jersey Restaurant and Hospitality Educational Webinar. This month, we are going to discuss the worker tip credit and tip pool. These are critical issues in New Jersey right now because, as we will discuss at the conclusion of this webinar, there is currently legislation for the New Jersey Assembly that would eliminate the tip credit and require all industry employees to be paid minimum wage. The tip credit and tip pools are utilized by most restaurant and hospitality industry employers, but unfortunately, many businesses are not aware of the controlling laws and regulations and often unintentionally end up with significant liability assessments and penalties from the state or federal Department of Labor because of these unintentional failure to comply issues. In this webinar, we are going to discuss 1, what is a tip? 2, who are tipped employees? 3, what is the tip credit? 4, what is a tip pool? 5, how do employers legally utilize the tip credit and tip pool? And 6, what are the best practices to ensure compliance and avoid liability? So let's begin with the most basic question, which is, what is a tip? It would seem that this would not need to be something that's defined, but the state of New Jersey has defined specifically what constitutes a tip for compensation and employment purposes. A tip is money that is given to an employee by the customer in recognition of the service performed for that customer. The tip is in addition to the amount charged for the service performed, and the customer decides to whom the tip should be given and how much. A tip can be a cash sum given directly to an employee. It can also be given by another manner of transfer, such as adding it on a credit card or designating it as part of a gratuity when entering into a contract for catering or other hospitality services. Tips belong to the employee, regardless of whether or not the employer has a tip credit or tip pool policy in place. The tips are always considered to be the compensation and wages to the employee, not the business or management. An employer is prohibited from using the employee's tips for any reason other than compensating that employee. So what could be what would be an example is really in your industry, what we're talking about are using tip monies to offset processing fees or credit card charges or debit card charges. It is illegal to do that. We can't offset that 3% or whatever percent we're paying for the debit card or credit card service against employee tips. Now, another question that comes up often is whether a service charge constitutes a tip, meaning if a business imposes a service charge based on the type of event that's being done, whether it's a catering event, whether it's a large hospitality event, or if it's a group dining together at a restaurant of a certain size. Does that service charge constitute a tip? And the answer is no. The service charge is considered monies that are being assessed by the business, by the employer, for the employer. Now, that does not mean that the employer cannot allocate some of those monies to tipped employees, but what you must understand is that service charge monies do not count towards satisfying the tip credit minimum wage, meaning that if you have employees who are being paid under the tip credit law and you impose a service charge and you allocate a percentage or portion of that service charge to the employees, that money does not count as bringing that employee from the minimum tip credit amount up to the minimum wage. When we have events where there are service charges, it's important that at the end of the day and at the end of the week, when we're reconciling the employees' wages, that we make sure that that money isn't considered to be satisfying that minimum wage threshold. And that may result in the employer having to pay additional monies to that employee to bring them up for minimum wage for those hours. So we know what a tip is. Now let's talk about who are tipped employees. Well, a tipped employee is really any worker, whether they're full-time, part-time, seasonal, or temporary, who are engaged in an occupation which traditionally, customarily, and regularly receives more than $30 a month in tips. That seems like a pretty de minimis amount. And so it's a pretty low threshold to have to satisfy. So in the Restaurant and Hospitality Association, your servers, bartenders, front of the house people are going to generally satisfy that. There are other industries, in which tipping is maybe a practice by some patrons and customers, but not by others. And there's a question as to whether or not that those workers may be tipped employees. But in the Restaurant and Hospitality Association, there certainly is no question about who constitutes our tipped employees. You say, well, wait a minute, what if somebody's sick for a month? What if they take 2 weeks off? What if they're on approved family leave, paternity leave, maternity leave? Well, that doesn't impact their qualification under this $30 tip threshold. If you didn't receive $30 in tips in a month because you were out because you broke your leg, that does not make this employee now a non-tipped employee. So now that we know what a tip is and we've discussed who our tipped employees are, let's talk about the tip credit. As we all know, the general rule is that all employees have to be paid minimum wage by the employer. Now, there's some exceptions to this rule, and one of those that impacts the Restaurant and Hospitality Association is the tip credit. The tip credit law permits employers to apply up to a set maximum amount of an employee's tips towards the obligation to satisfy the minimum wage. That means you're taking a credit for the tips they receive. The maximum tip credit is a function of the minimum wage, and it's tied to that in New Jersey. And as we know, minimum wage in New Jersey has been going up consistently as per the statutory changes about 5 years ago. Right now, the current minimum wage in New Jersey is $15.49 per hour, meaning that the current maximum tip credit is $9.87 per hour, meaning that a tip eligible industry employee must be paid a reduced minimum wage of $5.62 per hour. Now, we still, as we know, have to be able to demonstrate that the tips that employee received, employee or employees received, would take them from that reduced minimum hourly rate of $5.62 per hour up to or above the statutory minimum rate of $15.49 per hour. What do you as an employer need to do to properly utilize the tip credit rule? The first is that every employee who is going to participate or going to be treated as a tipped employee and for whom the employer is going to utilize the tip credit, they must be informed in writing that they are a tipped employee. And that document, that disclosure sheet, should contain the following information. The first is that the amount of the hourly cash wage that is to be paid to the employee. So in 2025, we would provide our employees with a document that says this is your tipped worker notification form. Your cash hourly rate is $5.62 per hour. The tip credit that is being taken by the employer is $9.87 per hour. We have to tell them that in the event that their cash hourly rate plus the tips received do not meet the minimum wage of $15.49 per hour, that the employer will make up the difference and they will be paid a guaranteed minimum of at least a minimum wage. Now, we have to include a statement that the tips that are received by the tipped employee will be retained by the tipped employee unless the employer has implemented a valid tip pool policy and program, but not where a tip pool policy or program doesn't exist. We disclose to them in writing that these tips are your wages, they are your compensation, they are not the property of the company or management. And the law concludes by saying that the tip credit does not apply to employees who are not given these disclosures and information. Now, that's very important because that means that if a business does not make these disclosures to an employee, and that's why we recommend it be done in writing so there's proof, that if these disclosures aren't made, the tip credit isn't valid. So the employee is treated, the government views it as though the employee has not been paid minimum wage. And so the employer would be subject to one, making the employee whole for the unpaid wage amounts, for the difference between the cash rate paid and the hourly rate. And then they would be subject to the various penalties, interest, and assessments. And so it is absolutely critical that if your business is utilizing the tip credit, that you make these disclosures to the employee. Later on, we're going to go over our best practices and how we should handle this on an annual basis in order to really limit our liability and ensure compliance. So another question that often comes up in the wage and hour context, in the tip credit context, in the Restaurant Hospitality Association is overtime. I can't tell you still to this day, I have many clients who contact us and say, I didn't realize that this person had to be paid overtime. They're a tipped employee. So to be clear, every worker who is non-exempt, and we've discussed in our seminar in January some of the exemptions that would make you an overtime exempt employee. But if you are a non-exempt employee, then you are entitled to be paid an overtime premium for all hours worked in excess of 40 hours in a week. When it comes to the tip credit does not apply to overtime hours. It applies only to the first 40. So what that means is that if we have an employee who's a tipped employee that works 44 hours in a week, 45 hours in a week, 46, 47, 48, 49, or 50, that for each hour over the 40 threshold, they have to be paid $23.24 per hour in 2025. And the reason for that is that's the current minimum rate times 1.5, time and a half. And we are not permitted to take a tip credit for that overtime premium. The overtime premium must be paid in full. So another reason why we have to make sure that we're tracking all the hours that our employee works, that we are being cognizant of whether they're working overtime or not, and that if they are, that they're being paid the minimum base hourly rate of $23.24 per hour for all overtime hours. So another question that often comes up is, what if an employee does some tipped work and some non-tipped work? In the restaurant industry, and I'm not really comparing jobs here, whether you have two different jobs. This is really about the actual physical work you're performing, because tipped work is work that's being done in the context of how you would traditionally get tips, which is serving people, working as a bartender, and those activities. However, there often are tasks that are assigned to workers in the Restaurant and Hospitality Association that are not traditionally tipped, such as putting silverware together, setting tables, maybe doing some limited cleanup and maintenance. So in the state of New Jersey, if a tipped employee spends more than 20% of their working time performing non-tip duties, so in this case, we're really talking about employees who might be doing the cutlery work, maybe they're cleaning, maybe they're setting tables, maybe they're being assigned some limited marketing responsibilities. So long as the amount of time that they spend doing that is less than 20% of the total time worked for the week, then the tip credit applies to all of the time worked, right? So let me give you an example. Suppose a waitress works 40 hours per week. She spends 5 of those hours per week, doing various cleanup, table work, and the question is can the employer still take a tip credit for those 5 hours? The answer is yes, because 5 hours is less than 20% of the 40 hours worked that week. This is known as the 80-20 rule. So long as 80% of the work performed is tipped work, the employer is permitted to take the tip credit for the entirety of the hours worked during that week. Now, the second question is, what if an employee has multiple roles within the organization? What if there's somebody who does hostess work, they're a waitress, they're maybe a bartender, or even sometimes a fill-in manager if they've been with you long enough and they're experienced. So for the job that the employee regularly receives the tips, the employer is permitted to take the tip credit. But if in wearing these multiple hats, the employee undertakes work that is not tipped work and is not traditionally or customarily tipped work, then the employer cannot take the tip credit for that. So that's why it's very important that if we have employees who wear multiple hats within the organization, that we document each day on our schedule, on their shift assignment, that what they're doing, server this day, bartender this day, hostess, fill-in manager, and that it's clear so that we ensure that we're paying employees the correct amount for the work done. Because if we have somebody who's performing non-tipped work or working in a non-tipped role, we cannot take that tip credit. We have to make sure that we're paying them at least a minimum wage or whatever the agreed to rate is for that type of work within your organization. The next question, the next topic we want to discuss is the tip pool. So the tip pooling occurs when employees combine some or all of their tips and redistribute them among themselves at the end of the work shift or at a designated time, such as the end of the work week, or maybe every Friday, maybe every Sunday, right? Employers often do this to ensure that the staff who are supporting the tipped employees, our runners, our busboys, are getting, some allocation. And an employer can certainly establish a tip pool. A tip pool should be in writing. It should say, one, who's going to participate in the tip pool? It should say, two, how is the tip pool money going to be allocated? A lot of employers utilize points. Sometimes it's just a percentage based on the position. Whichever methodology you go with, you have to ensure that it's documented. And so we want to say who's participating, all of the roles that participate in that. And this is to demonstrate that we are not permitting management to participate in the tip pool. Two, we want to say what's our system of allocating the tips. We have to explain that in writing. It's important the employer recognize that management, the employer, anybody other than the tipped employees is not permitted to retain or receive any of those tip monies. Management cannot participate in the tip pool. Even if a member of management calculates the tip pool distributions and tracks it and does all the work that needs to be done, that individual cannot be compensated for that work with tip pool money. Now, the business can say, all right, manager, we're going to give you, an extra $100 a week of our money for your coordinating, tracking the tip pool monies, allocations, distributions. But that money cannot be shared with any of the non-tipped employees, cannot be taken by management. That will invalidate the pool and result in significant liability. So where are areas of concern when it comes to tip credit and tip pool potential liability? So there's really two that I want to talk about. The first is not paying the correct minimum reduced hourly rate. It seems you would say, how does that happen? But unfortunately, I can frankly say that over the last few years, I still get a number of calls every year with this exact issue where an employer recognizes that the minimum tipped hourly rate was not correct. And how does this happen? Well, minimum wage in New Jersey continues to increase, which as that goes up, that means that the minimum amount that we have to pay pursuant to the tip credit goes up. So you may use a third-party payroll company, you may have an application. You can't rely on those applications, those TPAs, to get this correct. In fact, I guarantee if you review your vendor agreement with that TPA or that application, you're going to see that there's language in there in which that entity specifically has you waive any liability against them for any inaccurate calculations which result in unpaid or underpaid wages. And that also means that they're not responsible not just for the wages, but not for the penalties, the interest, the fines assessed by the government. So you're trusting these TPAs and applications to perform the service for you, but they are very specifically exempting themselves from liability. And so it's really critical that you examine and you review the minimum hourly tipped amount that our tipped employees are receiving. Like I said, within the last 2 years alone, I can think of at least 6 clients who've contacted me where their payroll company did not pay the correct minimum hourly amount. And the penalties in those situations are very severe and draconian. If an employee is not paid the correct minimum hourly rate, the state of New Jersey treats it as though they weren't paid those monies at all. They ignore the tips that they received. And so the state views it as you only paid them $5 an hour, and they disregard the tips that they received. And so the employer ends up being responsible for, tens, I've even seen hundreds of thousands of dollars in what ends up actually being a windfall to the employee. And then there's additional assessments, fines, and interest. So it is critical that even if you utilize a TPA or application to do your payroll, that you're every year, maybe even twice a year, confirming that they're paying the correct minimum amount to your tipped employees. The second is that employers don't have written tip pool policies. And this gets a lot of employers in trouble, even if they're doing the right thing, even if they're complying with the law, because when we don't document what the tip pool is, who participates, how the points or the allocations are made, when those allocations are made, then we'll leave ourselves open to dispute from employees. And very often, not having the written plan, not saying who's going to be responsible for calculating the allocations, how the money is going to be tracked, where the documents are going to be tracked, when it's going to be distributed, even if nothing was done wrong, because that's not clear and it's not written, it creates the opportunity for a disgruntled current or former employee and their attorney to make allegations that we're not properly operating a tip pool. And again, that's viewed as theft if you're taking the money from the employee. Because that's the tipped employee's money. And if you're not operating a tip pool correctly, one, it's viewed as taking their money. And then two, you're not going to get the tip credit. So the employees will be considered to not have been paid that minimum wage amount. So what are the best practices that employers in the Restaurant and Hospitality Association can implement to avoid liability on these issues? First is the written notice of tip credit. As I said earlier, at the time of hire, and I recommend each year thereafter, that the employer provide each tipped employee with a written notice that informs the employee that, one, they're classified as a tipped employee. Two, what the tipped employee's minimum reduced hourly rate is. Three, what their overtime rate is, and inform them that, yes, you will be paid overtime premium for all hours worked in excess of 40 hours. Also, each year, confirm with your TPA, confirm with the application that you're using for payroll, confirm with your attorney that you're paying the correct amount of the minimum tip credit rate. It's a simple phone call, takes about a minute, and it can save you tens, if not hundreds of thousands of dollars. Two, employers need to have hard copies of proof that the tipped wages were received by the employees and that the tipped wages plus the reduced hourly rate combined together show that the employee was paid more than the statutory minimum wage, more than that 15 and change, that's the current minimum wage. We have to be able to demonstrate and provide through documents that our employees, through both the minimum hourly tip credit amount and the tips they received together exceed minimum wage. It is our obligation as an employer to be able to demonstrate that should an employee bring a claim against us, or more realistically, if the Department of Labor were to come in and do an audit. 3, the tip pool. 1, the tip pool must be in writing. This written document should be given to employees at the time of hire. It should be given to them each year. And if there's any modifications to the tip pool plan during the year, it should be documented and reissued. This document should state which employees by job title are eligible to participate. It should say, how will the allocations be calculated? When will the distributions be made? There should be written documentation of the tips that were distributed to each employee through the tip pool. And we also want to document which employees on each day, each shift, were eligible to be in the tip pool. And this goes back to if we have employees that wear multiple hats within our organization, we want to ensure that we can demonstrate that that employee was working in a tip eligible role that day, or that employee was not working in a tip eligible role, and that's why they did not receive tips or were not part of the tip pool for that specific day. If we take these basic actions, which really just require about 10 minutes of work each year to implement, we will really have managed our risks and ensure that we'll be protected from a wage and hour claim from an employee, or we'll have the proper documentation to prove to the Department of Labor, whether state or federal, should they come in for an audit, that we are in complete compliance. Obviously, the tip pool and the tip credit are a critical part of our industry. However, to ensure that we are properly protected in managing our risk, we need to take these simple steps. And now I want to conclude by discussing the new legislation that's before the New Jersey Assembly. At the beginning of this year, a single assembly member introduced legislation that would phase out the tip credit. That means if this were to go into effect, if it were to be passed by the Assembly, the Senate, and signed into law by the governor, that after a certain period of time, employers would no longer be able to take a tip credit, meaning that these employees would all have to become minimum wage employees. The proposal is to have this phased out completely by 2030. So essentially it would allow for 4 more years of the tip credit. The legislation, but each year the tip credit amount would get less, meaning that the required minimum hourly rate the employer has to pay goes up. For 2026, the legislation proposes that the tip credit amount would be $7.90 per hour. For 2027, it would be $5.92 per hour. For 2028, it would be $3.95 per hour. And then for 2029, $1.97 per hour. And what that means is that by 2029, you would only be able to pay the tipped employees essentially $2 less per hour than minimum wage. So the effect of this, one, obviously, employers would be required to pay tipped employees the full minimum wage, regardless of the tips earned. You would have to pay them right now, which the minimum hourly rate is $15.49 per hour. That's going to go up each year too. So I wouldn't be surprised if by 2030, we're somewhere around $18 per hour. This will significantly impact the economics of the Restaurant and Hospitality Association in New Jersey. The NJRHA is advocating against this right now. On Thursday, April 10th, 2025, the NJRHA organized a day of action in Trenton to educate the Assembly Committee on this issue and to let them know the concerns that both employers and employees have. Because frankly, our analysis of this is such that we believe this would obviously have a negative impact on both the employer by increasing employment payroll costs, but we also believe that it'll harm the industry because it will discourage individuals from wanting to become workers in this industry, because it will likely lessen the amount that they would receive through tips as the public becomes aware that their hourly rate is going up New Jersey no longer recognizes a tip credit, people may say, well, I don't have to tip anymore. You know, the restaurant workers are being paid more than they were. They're being compensated like everyone else. But the reality is that we all know that most of our tipped employees earn far, far in excess of the minimum wage. And in fact, there was testimony before the Assembly Committee by one server in our industry who said that when she divides, she looks at what she earned each week versus the hours she worked, she's usually earning somewhere around $45 an hour. This would truly be a devastating outcome for the industry and for the workers. The association is working very hard on your behalf to advocate against this. And if you'd like to know how you can support the association, how you can support your business and make your voice heard, please contact Amanda Stone, who's head of advocacy for the NJRHA, and she will assist you in letting you know what steps you can take and who you can contact. I hope this has been educational. I hope I've provided you some knowledge on how to best implement your tip credit and your tip pool policy. Of course, we're always here to answer your questions, as you know, as NJRHA members who are provided with a consultation, a free consultation with our firm. This is truly an area of the law where that ounce of prevention is worth it. Unfortunately, getting it wrong on the tip credit and the tip pool can result in very significant liabilities to an employer and real windfall to the employee. And so if you ever have any questions, please do not hesitate to contact us here at Mandelbaum Barrett. Thank you very much and have a great day.